Meeting of the Bylaw Review Committee meeting to order at 6 o'clock. If there's anyone recording other than LCAT, state your name. Hearing none, we'll go ahead and get started. With us is our Planning Zoning Conservation Director, Rob, and our consultants from Barrett. And they will be giving us a presentation on the zoning diagnostic report, where we will have the ability to ask questions and go ahead and get started.
So you guys want me to introduce the consultant first? So share some background. Okay. So you joined. Oh, sorry. So thank you for the invite today. Rob Witchell, Director of Planning. So I have with us Judy Barrett of Barrett Planning Group LLC, a firm that's based in Hingham, Mass. She's been doing this kind of work for a long time. So basically what you have before you, what was sent to you before this meeting, is a zoning diagnostic report. And basically what this document achieved was to look at our zoning text in its entirety and just look for everything that potentially is wrong with it, things that are looking good with it, kind of like a comprehensive and honest analysis and feedback of the zoning bylaw. There's going to be another document that follows this one later on in the process. So we are contracted with Judy and her team to have them provide recommendations after this discussion. So the whole point of this meeting today was to introduce this report to the committee, to have them field any questions or concerns you might have after your review of this report. Then potentially discuss anything else that they think is helpful on their end for next steps after the fact. So Judy and Bob, you guys can take it away. Yeah, she's muted.
Thank you. I just want to make sure we also introduce my colleague, Bob Mitchell, with whom I frequently have the pleasure of working on zoning projects. And you'll probably hear from both of us kind of throughout this meeting. So consultants can't go to a meeting without slides. So I just kind of put together a few slides to kind of walk through the report. I'm sure you've all seen the report, but nonetheless, for the sake of those who perhaps haven't had much chance to think about it, I would like to present those slides. And I think I probably have screen share permission. This is excellent. So hold on.
Yeah. Thanks, Judy.
You can see that?
Yeah.
Yes.
Okay, super. So Bob and I have worked on several of these. They're always enjoyable, and they're always a little bit different. There are some things I think we find in zoning bylaws we're asked to review that are fairly typical or common, and other things that jump off the page and you say, boy, I've never seen that before. And I can't say there's too much here that made me feel like I hadn't seen it before. But so I just want to tell you a lot of the things that we noticed, we have seen in other zoning reviews as well. And I want to just kind of go over the overall structure of the audit, kind of the key issues that we found, and how they sort of divide between technical and policy considerations. And then we can just open it up for discussion. So bear in mind, I can't see you guys now. So if you are dying to interrupt in the middle of this because you don't want to wait till the end, that's fine, but you may have to holler at me because I can't see you.
Noted.
So it's a comprehensive review of the zoning bylaw. And by that, I often mean, what's a comprehensive review? You're literally doing a close reading of a very dense document. And also trying to consult with other people who are users of it to do a reality check on whether the things that you're seeing are commonly experienced or understood at the local level by a variety of users, whether it's members of town boards or local developers or business people or whomever who may have come into contact with the zoning bylaw. It is mainly a technical analysis. So when we look at technical considerations, we look at the structure or organization of a bylaw. How user-friendly is it? In other words, how easily can people find information in the zoning bylaw? Are there internal inconsistencies, both at sort of the text level, but also between sections? Are there places where there's redundancy or near redundancy? And sometimes near redundancy is even more disconcerting because you might find two paragraphs that are awfully similar, but there's just a few words that are different and you don't really know what the town is trying to do. Conflicts with state or federal laws and judicial decisions as well. We tried to focus on kind of key points rather than doing a line by line review of the bylaw. And then also I just want to say, although this was mainly a deep dive, close reading on our part, we did talk to a few people. Rob gave us contact information for a few folks in the community for us to talk to, just to do a reality check and get their perspective on both the bylaw and how permitting is working and what the development review process is like and so forth. So it was very helpful to get a chance to talk with people in East Long Meadow, in addition to doing the, as I said, the sort of technical or close reading review. I think you're going to find that there's sort of the report sort of divides issues into two buckets. One is kind of strictly the technical review, the things that make the bylaw hard to use, or, those legal conflicts, as I mentioned earlier, things that just aren't clear. So technical things that you could fix without disturbing, or hopefully not disturbing, any sort of larger policy considerations. But then there's also policy considerations. We were asked to kind of comment on that as well. And those are things where at best what we can do is sort of point out where, this is maybe out of sync with contemporary practice or out of sync with things we heard from the community. But those are things that you really need to discuss locally and give us direction on. Whereas often the technical review fixes are somewhat easier to do. That you either fix it or you don't. And ultimately, I think we're going to need some direction from the town, whether it's you folks or others, on what you want us to focus on. So we can make lots of recommendations, and we have clearly made a lot of findings, but we need to know what you guys think is the most important content, or especially things that you think maybe we missed or didn't elaborate on enough. So we'll look at the technical points first. And Bob, I'm just going to say generally, as we've done before, just jump in if there's something you want to mention to elaborate on.
I will.
I bet you will. So structure and formatting. I think you probably all know the bylaw doesn't really have a consistent structure or organization. The internal organization varies a lot from section to section. And I think I kind of know why that is the case. It's not an uncommon problem in cities and towns. There are sections that overlap kind of within and across articles, so you've got articles, you've got sections, you have subsections. But sometimes it's just not clear why something is where it is placed. It's sometimes a little bit difficult to understand why a section is in a particular article or why it perhaps is not somewhere else. And I would just say generally, when a zoning bylaw is inconsistent in its structure, it's easy for people to miss key provisions. It can, cause some delays in the permitting process. It can certainly make town boards sometimes appear to be inconsistent, even when that certainly is not their intent. So just the structure itself really could use some cleanup and would probably make the bylaw much easier for people to use, even if you didn't touch any policy issues. Bob, did you want to comment at all on this slide, or should I just move on?
No, I think just as a comment, somewhat of a general comment, one of the things we find when we work with towns and we talk to people in the town, that is a key reason why things get missed or people get confused, is the fact that in many bylaws, the same topic is spread either all over the bylaw or is spread in multiple sections of the bylaw unexpectedly. So if somebody, I'll just give this an example, it's not related specifically to the East Long Meadow, but if somebody's looking for a parking requirement and they see in the table of contents, parking section, 6.2 parking, and they go to 6.2 and they think they find what they're looking for, but it turns out that there's more parking requirements in 8.4 and more parking requirements in 10.6. And sometimes the same use, for example, has got a parking requirement in the first section and in the 10th section, and they don't agree with each other.
Right.
So it's that surprise of not finding the topic you think you're looking for when the table of contents says it's in this section, and there's nothing that informs you it's in 3 other sections.
Right.
So looking at how to organize topics, not always possible to do it every topic only in one place, but better organization of where topics are goes a long way to making the bylaw easier to navigate and find things.
Yeah, and I would just say it's not only easier on applicants, it's easier on the town boards. It just reduces the likelihood of error if you actually know where everything is that someone needs to account for in a particular application. The district regulations, they're broken up across different sections. There's doesn't seem to be any internal logic to how they're grouped. People have to kind of cross-reference several different tables or articles to meet the requirements of just a particular use in one district. Without clear structure for the rules, I think people can struggle to identify like all the requirements they have to meet for a particular project. And scattering related regulations across several sections can affect the long-term maintenance of the zoning bylaw because sections are likely to be missed during updates and amendments, leading to contradictions, increasing over time. And this is just a really common problem. As bylaws are amended over time, if the structure that someone is supposed to be working within is not clear, it's really easy for things to fall apart. And all of a sudden regulations get scattered, and it wasn't ever anybody's intent, but that's what happens. So just the way use regulations are organized in the bylaw really could be, I think, clearer and more intuitive. Do you want to add anything, Bob?
No, I'm good.
Okay. So standards and regulations section introduces or amends regulations for uses that are not included elsewhere in the bylaw. And in several places, the regulations in the table contradict other sections. And we talk about this a little bit more in the report. There are also administrative mistakes, like a page marked amendment and with incorrect, cross references or incorrect sections mentioned. Regulations only listed in the table of uses can easily be overlooked, leading to confusion for users. So there's just, I think, some real cleanup that needs to happen with the table of uses. So it's just more intuitive for people to use and understand, perhaps, where else in the bylaw they need to be looking, such as just for simple cross references would be very helpful. On readability, there are some sections that just need reorganization so they read better or they're easier to understand. You have sections in your bylaw with like large sections of unbroken text. I sometimes call these Jamesian paragraphs because that's how Henry James used to write, which is these long paragraphs that just sort of went on, sometimes an entire sentence, one paragraph is an entire sentence. And there are times too when there's just excessive, what I would call sort of legalese, or wording that just weights down the sentences and makes them harder to read and understand. There's really no reason for that. The clearer and simpler the language is, the more likely it is that people are going to understand what's being asked or what's being said. Again, with text that's dense and difficult to understand, it just increases the likelihood of mistakes being made in interpretation or enforcement. And applicants will struggle to identify what they're supposed to be doing. And as I said earlier, oversight boards can miss relevant regulations they should be enforcing. And this is especially important to me because I happen to sit on a ZBA in my own town. And I know what that frustration is like when you just realize that this simple project that's in front of you actually requires you to master several sections of the zoning bylaw. Bob, were you trying to add something in there?
Well, just one specific example we found, one of the sentences in the bylaw, there might be more, but we did find one that was 166 words long. Just as a future reference, don't put sentences in your bylaw that are 166 words long. Pretty hard to understand what you're trying to say.
It is, and those are relatively easy things to fix too, which is the good news is those are not hard to fix. I mean, just breaking things down into lists when you have sentences that are that complex and long, I can just readily take something and make it much easier to understand with relatively little effort.
Can I jump in real quick, Ralph Page? I know the paragraph you're talking about. It's 450, section 3.4. That is verbatim for state law.
Oh,
Uh,
yeah.
We actually took it out of the state law, and that's why it's 166 characters.
Yes.
I would think in a situation like that, there's no, if you start changing it, shortening it or whatever, you may miss some of the meaning within the state law. I mean, would I be incorrect in saying that you're better off using the exact language under the law if that's what you're trying to get across?
Well, you can use the exact language often without replicating, putting it all into one sentence.
Right.
You
State,
can break it down into either, sometimes you can break it down into list.
Yep.
Or sometimes you can break it down into multiple sentences. So as long as you have that information, it's not necessary to have everything that's written in a state statute, which if you use the state statute 40A much, or practically any state statute, you know how poorly worded they are. Drives the court, drives the judges nuts. So just taking the state statute format and language and putting it in bylaws is often not helpful. So you look for a way, can this be broken down with the same words or almost the same words into a list, or just separate sentences to have the same meaning and not unduly ruin the intent of the state statute. And we run into this all the time. So we've done this many times, and usually there's a way to make it easier to read and understand without following the format of the.
I mean, if it's any consolation, just spend a nice Sunday afternoon reading some of the case law under section 6 of chapter 40A, which is the non-conforming uses and structures section, because some of the decisions are delightful in terms of their recognition of how badly written that section is.
and I think that's my main point, is if you have, 30, 40, 50 court cases that can't figure this out, I think if we try and simplify it and break it into sentences, our meaning and our interpretation probably won't meet the state law. And again, this came through E-code actually when we were doing it. And that was the determination, is that, heck, if they can't understand it, how are we gonna try and simplify it for the residents when the state can't even do that?
Well, the answer to that is, yes, the courts say they can't really understand that, but nevertheless, the court make decisions
Right.
and say, this is what we're basing our decision on, what we believe, what we interpret this to mean. And from this point forward, especially appeals court and Supreme Judicial Court,
Right.
this point forward, this applies across the state.
Right.
And to how we have interpreted this paragraph or this sentence or whatever. So there are answers in the court decisions as to what that means.
Yep.
From the court's perspective, and from the court's perspective, that's what it means for all the towns and cities. So sometimes you just can glean, you can just take what the court said and turn it into what you say in your bylaw.
We tried that with our solar bylaw, and the Supreme Judicial Court again ruled against us, even though we followed the previous. So, and I do understand what you're saying, and it's very difficult when you read this to even interpret it, even when you know the bylaws. And chapter 40A, some things I just think are maybe too complicated to try and change. And I think the couple of examples were the reason we used the whole thing.
Understood. And I
Anyways,
think
we
all
can
we're
move
saying
on.
is,
Sorry about that.
no, it's okay. I mean,
No.
it's your decision. I just think, we've had experience with this, and it's something we can point out.
Yeah.
I don't think cities and towns should be enslaved to badly written legislation.
Yeah. I'm gonna agree with you there.
Yeah, I think we can, as I said, we've dealt with this in other towns, and we draft up something that we take a long paragraph and say, here's how it could read or how it could be listed, and we'll give that to you, and you can tell us, yeah, that looks good, or no, we think we're losing something here. So, but
Right.
at least show you an option.
Right.
Thank you.
And that brings us to non-conforming uses, structures and
got that.
lots. My favorite topics.
Love this topic.
So Bob, I'm actually gonna bump you into a little bit on this because I know you were the one who sort of picked this section apart, but the bylaw is not really clear about the special permit granting process for non-conforming uses and structures, and it's missing information that's kind of commonly found in some other communities. It doesn't address at all kind of how findings work related to non-conforming uses and structures. It's a little unclear, when does a change or an alteration actually require a special permit? The provisions that typically pertain to single family and two family lots are not there. A little bit of lack of clarity around the difference between a variance versus how a lawfully pre-existing nonconformity is addressed. That section really would benefit from, I think, some significant revision. Do you want to add anything, Bob, or not?
Well, I think much of the section is just kind of bringing it up to date with
Yeah.
Putting it into conformance with state statute and some of the more recent court decisions. Some important information that Judy's pointed out, you know, the exemptions for single family and two family lots really should be in there. The difference as to when you need a variance and when you need a non-conforming finding under, a finding under the non-conforming. I spent an hour today on the phone with a zoning board chair of another town who didn't know there was a distinction between when you need a variance and when you need a non-conforming finding. And it had created a huge mess in the town. And they didn't have any language in the bylaw that defined that, so everybody reading the bylaw could understand that distinction. So I think this is one of those sections we always run into that's kind of partly poorly written, because this is section 6, as some of you probably know, is the number one section of 48 that the judges hate. So we try to narrow it down to the where we can, not narrow it down, but to try to clean it up, try to change some of the vague language, try to add language that is specific and should be there because it is it addresses a lot of issues. Single and two family lots, obviously, that exemption is an important thing for everybody to know.
Right.
So again, we will work on some drafts to show you, more specifically what we're suggesting, and then we can have a discussion about, what you think, and what you think of the drafts. But in the meantime, if the town could tell us they think something's missing, or some section of your non-conforming section is incomprehensible even to the board members and the staff members, that would help us as well. So yeah, this is usually one of the biggest sections we spend more time on with the committees, because towns are all over the place with their bylaw provisions for non-conforming, because section 6 is so vague in so much of the language of section 6. So
Yeah.
we'll take a shot at yours and take a look at it and give you some ideas.
Yeah. Definitions. There's several issues I think we're concerned about with the definitions. Some of them are really quite vague. There is some contradictory language. Sometimes the definitions just don't align with sort of common definitions used for terms. For residential uses, in particular, one of the things we noticed was that in some ways the bylaw is attempting to kind of regulate use through definition, like how many units can be connected or the minimum size of units. That really doesn't belong in the definition section. It really is a regulation. And it's better to have the use regulations with the use regulations and let the definition stand on its own. So I think some cleanup would be helpful to you in the definition section of your zoning bylaw. And that we see this a lot as well. And Some of this happens because definitions over time get put in different parts of the bylaw. There's a definition section, but then a town is trying to adopt a model bylaw that came from somewhere, and definitions associated with that bylaw are part of the model. So it ends up being put in your zoning bylaw with the definitions not in the definition section, but in the section relating to this new provision that's being added. And it just over time really crumbles the structure of how people find out what things mean in the zoning bylaw. And even more so, I would say, as definitions get fractured across the bylaw, you increase the possibility of inconsistencies between, like a term being defined twice in a bylaw, but not necessarily the same way. So I think some of the definitions really could be cleaned up. Your bylaw doesn't have purpose statements for your districts. They can really be helpful to a special permit granting authority when you're trying to review a project and think about whether the applicant has met the requirements of the district, or at least the what the town is trying to accomplish within a particular district. I think it can be especially helpful when boards are stuck with this difficult job of trying to understand what things like character mean. Because it's just, people don't agree on what it is, and it ends up becoming a source of frustration for lots of folks in a permitting process. So having purpose statements for the districts, we think would be very helpful to you. The mixed use village district is a paper zone. It's not defined anywhere. It's not on the map. So you would have trouble enforcing it. Just to be clear, the Zoning Act requires all districts to be shown on a map. So when it's not on the map, you have a conflict with state law. And it seemed that there were some other districts that weren't on the map as well. And those things happen. Sometimes new districts are created, and they're created based on a map that's shown to town meeting, but that map doesn't get integrated with the zoning map. Those kinds of corrections kind of need to be made. So just, Bob, did you have anything else you wanted to add on this?
Yeah, well, just back in the purpose statements, one other
Yeah.
Reason to have purpose statements is if you end up in court
Yeah.
on a case that's some kind of an appeal related to a district. One of the things that judges will often look for, and sometimes include in their decisions, is what is the purpose of this district? You know, there's this argument about, is the district supposed to do this? Is the intent of district of that? We don't know because there's no purpose section. Or we know, here's the purpose section of this district that, well explains why this district was created. And that often will help the judge rule in favor of the town.
Right.
Because you have a clean purpose section, and then everybody should know what that means and should be followed. And if the town did, then the appellant loses. So sometimes the judges pay a lot of attention to the purpose districts in the right set of circumstances.
Right. Use regulations. There's contradictory language in the bylaw. Some of the requirements are hard to quantify. Like, again, this community character thing just shows up multiple times, and it's not clear what that means to you folks. There's some inconsistencies with state law, which you probably are already aware of, on ADUs, accessory dwelling units, and other Dover Amendment uses. There are some vague or contradictory requirements that are hard to administer and leave applicants unsure of what's required of them, and most certainly would probably leave boards questioning what's required as well. So I think just cleaning up, a lot of this is cleanup. It's cleaning up language. It's reducing inconsistencies and contradictions so that the document is easier for everybody to use.
Also want to say that so we didn't adopt our ADU bylaw until before those regulations from the state came out for the ADU. So that's why those inconsistencies exist.
Yeah, understood. I understood. We're just documenting what we saw, but I do
Yeah,
understand.
no worries. Yeah.
And you're not the only town that was in that boat. I mean, we have some other clients who were trying to be on top of this.
Yeah.
And went to town meeting and adopted something that then turned out to not be consistent with the ADU regulations. So I sympathize.
That's what we get for being ahead of the deadline for one.
You're not alone. You're not alone. A couple of the towns on the vineyard were in the same boat.
Yeah.
So there's some inconsistent language in the bylaw about how certain boards or bodies are referred to. And it's sometimes it's just hard to know, like, well, who is actually the permitting authority for this or some other use? Um, doesn't provide an outline of the roles and responsibilities and duties of the planning board as it does the zoning board. This is not an uncommon thing in zoning bylaws, but if you're going to have a planning board that has a lot of special permit granting authority, it's a really good idea to make sure that the planning board also kind of has a section in the zoning bylaw that says what it is, what its authority is, and so forth. There are subjective kind of criteria. I think you probably all know this, especially for special permits. The rules aren't clear for use, which certainly can lead to inconsistencies in how a board makes a decision and can be, discouraging or frustrating for applicants. So just when things are clear, everybody understands. The board understands, the applicant understands, the town staff understand. When the requirements are not clear, when the language is muddy, or sometimes even worse, when it's inconsistent, it becomes very difficult for people to work with the code in a sort of commonly understood way. There are a lot of other little things that we talked about, again, how it refers to various boards and commissions. There are a lot of cross-reference mistakes in the bylaw. And sometimes there's not enough information for someone to even figure out, oh, well, I went to this section, that obviously isn't what it is, where should I be? But it's not, you just can't tease it out of the language that is available. There's some words that are just used almost interchangeably in a way that perhaps they should not be. Things like setbacks and yards. It just can be very confusing to interpret because the language isn't consistent. So then I'm just on some policy topics. These are totally policy issues for the town, but the way multifamily and manufactured housing is treated in the zoning bylaw makes them both kind of difficult to do. If you're concerned about affordable housing and you're trying to provide more of it, you probably want to clean that up. The bulk regulations make your built out areas non-conforming, creates a lot of non-conformity in town, prevents infill development and hinders special provisions for certain kinds of uses. So there just seems to be a lot in the regulations that actually make it hard to do something, and we're not sure if that's intentional on the town's part. But it would sure help to know what it is that you're actually trying to accomplish. There are restrictions in the bylaw that kind of make it a little difficult to do some commercial uses or limit what business owners can do, such as banning outdoor seating. And those are things that typically communities are cleaning up today.
Hey, Judy, just go back to that last slide real quick. Could you just briefly explain, I guess the connection to, in terms of the bulk requirements, making those lots non conforming and how it relates to infill development? And I guess also give some background what infill development is, just for some of the people here don't know.
Sure. I mean, infill development is I actually call it incremental development, but you have spaces in your downtown district's an easy one to talk about. You have spaces in the district where you have a break in the form, and infill would help to kind of close that gap and create a sense of continuity at the street edge and for public realm. So infill development is an important tool. Sometimes a lot is underutilized, and being able to maximize its utility improves the sense of the pedestrian, the person's relationship to the street, relationship to businesses, and just builds a nice kind of town center or downtown or business district form. So that's kind of what infill is. It's incrementally filling in spaces. It's the easiest way to explain this. When you have lot regulations that require more land for a use than the land that would be available for infill, you essentially make that infill impossible. When you have setback requirements that would break the continuity of perhaps an existing sort of organic development pattern, but now the new setbacks would create a very odd sense of the space at the street. You defeat the ability to do that kind of infill or incremental development that is so essential for growing a business district that people want to be in. So that's kind of the way I think about it. But believe me, height regulations, lot regulations, and setbacks can render areas non-conforming, and people don't even realize that that's what's happening, but it is. And all of a sudden it becomes difficult to use land in a more efficient way. So it's a policy issue, but it's something I think we felt like we needed to point out.
One of the things, one aspect of this is, we deal with a lot of towns and town center revitalization and whatnot, and they're trying to bring in more business opportunities, more opportunities for businesses. A lot of that revolves around, local mom and pop businesses, smaller spaces and whatnot, but those are often the spaces that cannot be built because of, and so you're losing the opportunity not only to have more business in your downtown, more jobs, more tax dollars, but maybe, depending on circumstances, being able to have more local people create businesses to locate in the town center. So there's a ripple effect in the economy and in the employment beyond just, creating a more attractive town center where you can fill in these empty spaces.
Right.
Just a thought.
Roles and responsibilities. In some ways, the zoning bylaw is stricter than state law for permit approvals or voting rules. 40A allows an applicant 3 years to exercise a permit, but the zoning bylaw currently says 1. Mullen rule, it was not clear to us whether the town has actually adopted the Mullen rule, but the Mullen rule allows board members who miss a meeting to participate and vote if they've reviewed like the tape of the hearing and read the minutes and so forth. But it appears that that is not possible in East Long Meadow.
So just to interrupt, Judy. So we did adopt it in town meeting, I think like in 2012 or something like that. The town clerk sent me a ruling for it. It just wasn't ever put into the zoning bylaw itself.
So that's something we can fix easily.
Yeah.
We can fix that.
And the town clerk would know which meeting that was voted upon as well. She was able to look it up pretty easily for me.
That's fine. So we can check that out. That's helpful to know. I mean, it was a little surprising to me, frankly, because so many towns have adopted the Mullen rule, but we're responding to the text as we received it. So thank you for that information.
Of course.
And then the site plan review guidelines, could be streamlined without necessarily compromising quality. Some of these documents are just very wordy and excessive, and then not clear. So just the roles and responsibilities, who does what are the various timeframes within which boards and commissions and applicants have to work. There are the areas like this that could be cleaned up in the bylaw. And that's really high level, but I think you guys have seen the report, so we're sort of happy to answer any questions that you may have, but that's high level what we talked about.
Oh, yeah. Yeah. If she stopped sharing, it should come back.
Yeah.
Yeah.
Awesome.
It's not the worst bylaw I've ever read. If that is any consolation to you. Bob and I have worked on a couple that were much worse.
I'm sure.
Yeah, these, your bylaw has good sections, some well-written sections, easy to understand sections. So it's not the whole bylaw is the problem. It's just much of its organization. And if you clean up the organization, it will make sense without changing a lot of the language. You're not in, like Judy just said, you're not anywhere near the worst bylaws we've run into.
Yeah, I mean, which in some ways is sort of advantageous for you folks because there's probably more we can do for you in the recommendations. It's not like this wholesale cleanup, which Bob and I have just gone through in a couple of towns. That was painful, but we got through it.
So do you find in towns with town meetings that the bylaws tend to be a little bit more scattered because the residents are actually writing the changes and then they're being adopted at town meeting, where now with a city form of government, it's the council that gets to approve everything?
Well, I mean, citizens can still petition for zoning changes, even if it's a council form of government, yes? So if citizens are gonna be writing stuff, then they're gonna be writing it whether it's town meeting or the council. Are you talking about the citizen petition process or just town meeting, perhaps not necessarily having staff?
So in the past, at the town meeting, a citizen would write the bylaw,
Mhm.
bring it to the town and say, I want you to adopt this. They would bring 100 of their closest friends, and no matter how bad the bylaw was written, it was adopted. Where at least
Yes.
now we have a process to go through,
Mhm.
try and fix it, try and straighten it out, try and make it more readable, find a place for it before it gets adopted.
Right. One of the things we always talk to towns about is exactly on this topic. Because if, they've hired us to fix the bylaw, so to speak, we fix it, they like it, and they take it to town meeting, and town meeting adopts it, and we say, okay, now you have to make sure you don't screw it all up again in 5 years. And they hadn't thought, they haven't thought about that. And we say, you have to have a process, where somebody is paying attention to the grammar, the punctuation, the syntax, where the amendment is being proposed to be put into. And some towns have developed, sort of an internal process to do that. And then when the planning board goes to town meeting, it'll say, look, the substantive issue may be fine. We were in support of that. But the bylaw is written as a mess. It's all screwed up. It's in the wrong place. It contradicts, these other two sections. We need time to work with the petitioner to fix those problems. Now, sometimes town meeting might say, well, we don't care about those problems and vote to approve it. But sometimes town meeting gets sick of hearing out how bad the bylaw is becoming all over again. And we're going to have to hire consultants again in another 10 years and say, okay, send it back, fix that, and then come back to us with a clean bylaw. So you kind of have to develop a messaging with the planning board and the staff, town attorney, even town meeting. Well, you don't have town meeting anymore, but town council, as things come in, if it's written by the planning board or the staff or the citizen, okay, who's reviewing it? Who's looking at the editorial aspect of it
Yeah.
before it gets to the public hearing or before it gets to a vote by town council to approve? So that's something to keep in mind going forward. How are you going to keep it in good shape?
What's our next set of deliverables gonna look like, and when should we expect those?
So I think we are going to need some direction from the town about like what you want us to focus on.
Okay,
Yeah.
We can start writing.
Yeah.
We'd love to
Yeah,
write.
and I guess this might be more for the group, like, how does that work for stuff like, what, if anything, are we changing for outdoor seating? Are we adding purpose statements to each bylaw? Is that something we
Right.
create? Are they writing? If they're writing it, do we review it before it goes to town council for a vote? Like,
So I guess
what's the order of operations?
the goal
Yep.
was to kind of give them direction for the policy stuff. I
Okay.
think it's pretty self-explanatory that we definitely want them to fix a lot of the technical stuff.
Yep.
Or at least give us suggestions on how they can rewrite some of those paragraphs that they brought up. That's a given. I guess the policy considerations is where they want guidance from us. So what do we see currently? I know it's only 10 of us in here making these decisions, but like what do we see as direction that we want in the next 5 to 10 years or even beyond that for this bylaw? They brought up a lot of policy considerations for us to kind of think about and examine. And I think it's up to us to decide, what's important, maybe what's not as important that can be focused on at a later time. And then whatever deliverables they create is going to be those recommendations that we'd ask them to provide to us just from those policy discussions that we're supposed to be having. And then the technical changes that they're going to do anyways. So that's kind of the gist of what you're bringing up, Judy. Is that correct?
Mhm.
One aspect of the policy decisions I'll just throw out there, we do this with every town and every town does it with us. Some policy decisions are fairly minor, if you will, and there's quick consensus about how to fix it or, the direction for the policy decision. And at the other end of the spectrum, there's big policy issues that are controversial, may have been talked about in the town in the past and never got anywhere because it was too controversial. gonna lead a lot of discussion from the town. That means a lot of time and probably not enough money to pay us to do that. So we usually end up with sort of a phase one and a phase two. Phase one is part of partly the technical and what other things of substantive can be done with our contract and with the town. And phase two are bigger issues that the town's gonna have to tackle down the road, next year or 2 years down to, resolve bigger policy issues with the town council and the planning board and citizens and all of that. So you'll end up with kind of that list from us, to help, and that helps sort things out somewhat.
So I guess, sorry, Connor, you can.
I was just gonna say, for the policy consideration aspect, are there things that you in your experience have seen in like other cities and towns that are similar to us and our size that you think we're missing that just aren't currently part of our zoning bylaw that we should give some thought to? Because I know you had some things that you saw that were in ours that you thought could use some change, or you at least flagged as policy considerations, but are there things that we're just totally missing that we aren't even aware of?
Off the top of my head, I'm not thinking of anything. That's an unfair answer to you, but that's my answer right now. I can't think of, I mean, nothing jumped off the page for me as, oh my God, why don't they have this? Given the size and
Well-
scale of the town, I think, I mean, there are things that I was a little surprised by.
Such as-
Well, the difficulty of trying to just do multifamily housing, I think, is really striking. I mean, this is 2025, and so I was a little surprised. I think you have really a sort of an archaic type of senior housing bylaw that I think probably needs to wholesale revision.
Mhm.
Nobody writes senior housing for 62 and over, and everybody has to be 62 or over. I mean, that's just, nobody does that. So those kinds of things I think really need to be up.
50.
Do they do 55 and older?
Well, it's, the fair housing law is 80% or more of the units in a development would need to be restricted for occupancy by households where at least one person is 55 or over. But not everybody has to be 55 or over. That's excessive. That is not anchored in the fair housing law.
Then you mentioned something else too, that's a FHA violation about the, I think you had mentioned this somewhere in the general laws 48. It's the uniformity of certain use categories applied across the district as a
Or
whole.
48, yep.
You had mentioned that there was one category, I think it was multifamily,
Multifamily manufactured homes.
but not just that, I think it was just multifamily or multiple buildings on the same property, multiple residences, the same property, I think is what the category is called.
Yeah, it's
And it only applied to town-owned properties.
Oh, yeah, that's an issue. And that we should have brought that up tonight.
And you had mentioned that because that violates, does that violate Fair Housing Act or is that something different?
It's a uniformity issue. It's like, so the use is only allowed within the district if the property is town owned.
Yeah.
And, that's a problem. You're not treating the use is multifamily, or the use is senior housing, or the use is whatever,
Yeah.
independent of who owns the land.
Mhm. Yeah. And that'd be included in your technical review, right? To look for those and,
Yeah, if it's not there, it should be, sorry.
no worries.
But we talked about it.
So I guess we'll be the most useful next steps from our end or from the committee's end to provide to you moving forward. Because they're only contracted to be at this meeting and then the next meeting when they present their results to us. So I guess there's gotta be some way that we can, I guess this committee could potentially meet again or discuss these things and then bring suggestions in a different format that you could use in
Yeah.
your recommendations phase. I don't know how the bylaw committee wants to tackle that.
That would be helpful.
I think the technical cleanup, maybe something like a template bylaw for future revisions, and then I won't call it a menu, but a menu of policy considerations.
Yeah.
And I don't know if this committee is the right committee for
The policy
So
stuff.
for policy stuff,
Probably not.
yeah, I feel like that would be a council level thing.
So
I guess-
how do we do that with the timeline we have?
Yeah.
We extend our timeline.
What's the timeline for when you have to have the second meeting with this
We should
additional
start with this.
report?
So we had told them,
Fixing commas and
we
stuff.
originally gave them a deadline of January, but I think Judy, we had discussed potentially pushing out to March for flexibility reasons.
Yeah.
I remember.
So we have a little bit of time.
We do, but I think town manager wanted to be March at the absolute latest to get that recommendations back.
Oh, yeah, I don't want to make it too long, but I'm just,
Yeah,
I think based off of that, my suggestion would be if they could go forward with the technical cleanup aspects and their recommendations for that.
Mhm.
And then if they could give us like Ryan was saying, a template and structure for like, here's how to fill in the blanks for future bylaws that we might consider.
Yeah.
But then also like, here's a menu for how to organize them going forward, because I'm sure as part of the technical, here's how to organize the stuff we have. But if we're trying to figure out where do we insert stuff in the future, are there like steps that we should follow to figure out where it might belong?
Yep.
Would be useful.
Okay,
And perhaps in the interim, while you guys are working on that, we could have a meeting with the council and the planning board, maybe even jointly, to discuss what we think some policy considerations could be. But if you provided us what the list of things we should even think about would be helpful.
yeah, we know you included.
Yeah.
Yeah, we know it's in this document already, but I guess it'd be helpful for this committee and for town council if you guys created a condensed version that's like a list of policy considerations to look at.
Okay.
So those questions could be discussed at these meetings.
Yep.
But yeah, it seems like you're emphasizing or prioritizing the technical review pieces that have to be changed. And then you suggested like a menu of what could be applied
Right. Yeah.
later on.
We have to clean up what we have now. It's
Yeah.
Yeah.
obviously, it's not the worst, but it's probably closer to the worst than the best that they've seen.
Right.
I mean, I think depending on what some of those policy considerations are, it would be nice to have some of those written and included by you as recommendations, but
Mhm.
at least you'll have something to work on while we hash out some of those discussions for you.
So part of my concern going forwards is adopting stuff like this. Obviously, the charter to adopt multiple changes at once was voted down.
Mhm.
We have to try and bring that back.
Yeah.
But I think if we put too many purpose things in it, it may become too controversial and then you lose the whole thing.
Mhm.
I just think we need to be careful as far as how we adopt stuff going forwards. Obviously, council should be talking about all of that.
Oh, I agree when it comes to like the actual adoption into law, but I would at least like to see some of the more of it than not in the recommendation. And even if it takes us a couple years to implement it piecemeal, that's okay.
I would agree with that.
So do you have like clear direction from us, Judy and Bob? Is there anything you
Well,
think?
I just would like
missing?
to
If-
throw one thing out related to policy issues.
Mhm.
The town knows what policy issues might be a problem or an issue or has been discussed already. The town council, planning board, you, staff.
Mhm.
So some of the information that comes back to us would be helpful if you told us what are some of the policy issues you've been discussing or got discussed 3 years ago and got dropped and, every town talks about policy issues. So what are you up and talking about in East Long Meadow?
Right.
And then we can, incorporate it into our draft and our thinking. We can look at it and, give you some feedback and then you can run it back up the chain to the town council. But it would be helpful to get some, town perspective on policy issues for the town.
Yeah.
And they
Right.
don't have to be part of the full bylaw that goes to town council. Like I said, some of them, you could say this needs more discussion for, a future time. And we won't include it in this draft that goes ultimately to the town council.
Look
And I
at the
guess how much of that is the purview of this committee? Or were we just like grammar police?
No, we're not. So it's a comprehensive review of all bylaws with recommendations for changes.
Okay,
Because we definitely have
That
concrete,
gives us pretty wide
broad scope.
array of.
I agree.
but it seems like, from what you guys discussed, like you definitely want the technical changes to be taken care of right away.
Yeah.
That's 100%
Mhm.
definitely something they want to see, or we want to see. But I guess the policy stuff, that seems like Connor, town council president, you want that to happen at the town council meetings with the planning board.
I think that would be helpful. I mean, we certainly can discuss it as a
Yeah,
committee here
right.
too, but I think
Yeah.
there's probably a larger audience to try to figure out some of.
Yeah, like if there's like
With that.
a, like a high priority policy change that we wanna.
And they get a voice on the back end because they can reject what
Yeah.
we suggest and keep the wall of text if they choose to do so for some of those things and such.
We should probably just take another look at the master plan and see what's in the master plan that's not in the zoning bylaw. We can do that. We should probably add that to our final report.
Okay.
Because that might get some policy issues.
Absolutely.
Yeah.
Hi, Judy. I'm Marilyn Richards. I'm over here in the corner.
Hi, how are you?
I'm hiding. I am a counselor, former planning board member, and just, enjoying this discussion.
Great.
I have a question, please, about what you stated about the mixed-use village district being a paper zone. I realize we don't have any district right now that addresses that because it's a new district. We created it just before COVID. There was a developer that was interested. We would have rezoned the property and then their project fell through. So is it okay to leave it in the bylaw the way it is until such time as someone else may take advantage of that opportunity? Well, went into
It's
that.
not mapped. It's not on the map, so it really
Maps.
shouldn't be in the bylaw at all. Now, if somebody comes forward and wants to do something like that in the future, you can always bring it back to town meeting along with a map amendment.
I
So
tried
one
to
of
find it on the map. It's not a map. The map has been
It's
updated.
because it was designed, but then COVID hit and then the developer didn't actually move forward with it from there.
So where is it?
So hold it. So I believe there's two separate things that you have here. One is a bylaw, which basically outlines what you could do in this district if someone so chose to change their property, come in for a zone change.
Yeah.
And adopt, basically say, hey, I no longer want to be in the industrial garden park. I'd like a zone change to the mixed use village district. If you don't have a bylaw for that outlining what you can do, then you can't.
Sorry, chapter 48 is very clear in section 5. All districts shall be shown on the map.
It's true. And if it's not on the
Not
map,
listed.
if it's not on the map, then you can't really enforce it. You have to
Right.
create physical boundaries for it. Even
Right.
if it's an overlay district too, like usually in that situation, if you made it like you could do a town-wide overlay district if you wanted to, but if you were to do something like that, you'd have to show it on the map in some way, shape or form.
It
So
has
are
to
you
have
saying that
identity.
that bylaw shouldn't have been adopted until such point in time that a change of zone was going to be requested to change the map
Or you could have done
and adopt them both at the same time?
Right,
When
right.
you create a district, you create the text of the district and you show it on the map.
You might want to go back,
That's what I thought I signed up for.
you might want to go back to
Mm.
when this was adopted by town meeting, the bylaw.
Mm.
And look at the letter you got from the Attorney General's office reviewing that, because normally when a town does this, adopts the bylaw, but doesn't put the district on the map, the Attorney General will say to you, hey, you have to have both the bylaw, the district in the bylaw and on the map. You didn't do the map. Put an amendment together and go back to town meeting and get it on the map.
So we didn't do
You
it
can
during the
find
town.
that letter, see if she says that.
We didn't do this at town meeting. We're a city form of government. We adopted this under the city form of
Oh,
government.
okay, well,
And we
same,
didn't
same
receive
procedure.
anything from the
Oh,
Attorney
okay, well, that
General.
explains it, because you don't send the bylaws to the Attorney General.
Right.
Exactly.
So they don't get reviewed, but
To make it legal.
for 40A applies to cities as it does towns, so you're still out of conformance with chapter 40A.
right.
So what you're telling us is when we went to our attorney, the attorney should have advised us not to do that.
I'm not commenting on anything from legal counsel. I'm simply telling you that chapter 48 is very clear. All districts shall be shown on the map.
And if it's not, that would just mean that the provisions of that zone aren't enforceable anywhere. Which would be fine, because we don't have anything under that zone anyway.
Enforce anyway.
Right.
Chapter 48 is very clear. All districts shall be shown on the map.
Yeah,
So the technical recommendation is remove it from the bylaw. If someone wants to come forth with something like that in the future, you can always go back to the council and say, we want to propose this district. Here it is on the map. Here are the rules and regulations.
So
We got a deal for you, and they
Yeah.
pass it.
3B needs to be struck.
Well, actually, Judy, I just thought of something else just now, thinking about our contract and stuff. I do remember we actually put in there a public outreach component on your behalf, and I guess working with the town. So maybe could we potentially use that as an avenue to get those policy, I guess, discussions going on with town residents in any way, shape, or form? And I think the way you word the contract is that the public engagement piece could be up to you guys to figure out how you want to do it. And this is like moving more into the recommendations part of the whole ordeal. Because obviously the audit report was just the technical analysis of the whole bylaw, right? And then you raise these questions that we discussed here today. But then afterwards, we have that next piece where, we have the recommendations that you'll provide, but also, reaching out and I guess coordinating a way to get opinion from the public as well. And I think, we kind of left it up to you to decide like what method you see as best. So whether it's like a survey, whether it's like a in-person meeting that we invite folks to come to. And I think, that could be definitely a good place to bring up those types of discussions. In addition to doing it in front of the planning board and the town council as well, because that could invite residents to weigh in on these things. So could that potentially be a good idea?
Yeah, we can certainly do something. I mean, my understanding, and correct me if I'm wrong, Rob, but I
Sure.
thought because you had the town center district going on and the housing production plan, that we weren't going to be doing a lot of direct engagement with the community because it was just too much going on. But we certainly more than happy to do. We could certainly. I sometimes I think a meeting is more helpful because you ask people, you ask anybody, like, do you think that Ace Long Meadow should have more multifamily housing? What do you think the answer is going to be? It's better to have a conversation with people and to be able to explain why a question is important than simply throw a question at them. So I think some kind of meeting would be a better option.
Yeah, we can discuss that too when we have our next team meeting about this, and then just find that time. Maybe I would say maybe early next year or something like that. Whenever some of this other stuff's kind of blown over a little bit, so we have space to just do this.
Sure.
In addition to this process, obviously, but I think those policy questions are pretty important because we can't just
They
I
are.
guess do that within this room or within the town council and the planning board. I think that has to go above and beyond and just invite. We've had good participation recently amongst folks in town. For the Jeff Speck event that we did last month, we had at least 60 people here. We had 80 people for the Centertown district. So we've been getting good numbers, and I think we could definitely attract residents who want to weigh in on this stuff.
Yeah, I mean, I'm just thinking again back to you've got a master plan. We should probably try to say, look, your master plan has these recommendations in it. What do you think? It's really remarkable to me when you go work on a zoning bylaw in a community. And people kind of forget what their own planning documents say, or things have changed, and so it's helpful to kind of calibrate. It would be great. It'd be wonderful if we could do it on a Saturday morning instead of in the evening, but I'm just putting in a plug for
I would agree.
how much I really have come to hate night meetings, but that's just me. It's just me, but we certainly could. We owe you that. I was trying to take my cues from you
Sure.
that you guys didn't want us to try to do a whole lot of public outreach right now, but you are correct. It's in the contract and I'm more than happy to do it. I kind of want to go back to the bylaw anyway, and in response to this question of what are we missing anything? Because I
Sure.
think I was just speaking for myself, I was so focused on the technical nitty gritty stuff that frankly is just a lot of fun to
Yeah.
pick up. That I'm not sure I gave it that lens, so I want to do that too. Before we call this report final.
Sure, yeah, and that's why we're flexible with the deadline being what it is, so we can iron out these sort of things when they come up.
Absolutely.
But yeah, no, obviously it's something we could consider, and I guess Connor and council, we can also take direction from you guys as well in terms of like what would be a better process. I guess it seems like at least having one meeting with members of the community would be helpful.
Yeah.
Yeah, I think that's a good
You
idea.
want people to know what's going on. I mean,
Yeah.
those can also be very educational too. I mean, part of it is just the making sure people don't feel like something's going on that they don't know about, but it's also educational. People sometimes have ideas about land uses or the impact of development that actually turns out are not necessarily accurate. And we learn a lot. There are things you hear from residents in a community that ordinary residents who aren't serving on town boards, they just have concerns and interests or things that they're worried about that it's helpful to us to know.
Yeah, absolutely.
Everyone at the Centertown district meeting had the same opportunity I did to sign up for this fund. So
May I, you had listed redundancy. I know in the past, a lot of the thought was to list certain things multiple times within the zoning bylaws because you may miss it here and you'll see it here. It sounds to me like what you're saying is put it in once in a specific area and that's the area, that's it. Don't do referrals, just list it where it's supposed to be. Did I pick up on that correctly?
Yes, you did. So
Oh.
one of my greatest frustrations is finding something in multiple places in a bylaw and it's not written exactly the same way.
Okay,
Well,
that's
It was written this way one year, and then a few words changed here the next year, and a few years later, it was like it morphed again. And all of a sudden, you have this inconsistency threaded through the bylaw in the way something is treated, just because somebody liked commas and somebody else did not. So I think it's best to get it clear once. Did I just insult an attorney? I didn't mean to. But it's just like, really, you run the risk of creating inconsistency and lack of clarity when you try to repeat things, when really the best thing is say it once and cross-reference it.
I remember me and the previous building commissioner, Dave Gardner, we would debate about several things in the bylaw all the time because it wasn't clear to either one of us how certain things were applied. Like we'd go back and forth, it'd say one thing here and the other thing would be different, but then you look
Right.
at the text very closely
that's it.
and it's like,
Told you what we meant.
yeah, or like if you look at the text itself,
Yeah.
like that can mean three other things within the text. It's like I don't think staff should be having those types of back and forths. It should just be you look at it and it makes sense to everybody. And you're like, wow, we can apply it this way when doing this development review for this person or applicant. So we can give them a clear answer and a clear path. I think that's kind of like the biggest frustration from staff is that the bylaw is unclear in certain areas. And like we have trouble figuring out the best way to do it. And oftentimes the building commissioner is the person that makes that call.
Right.
Which, broad powers they already have under the zoning act. I mean, the building commissioner, zoning enforcement officer, which our building commissioner is in this town, he often confuses himself because he might second guess something. He's like, oh, actually, you know what? The definition of farm is actually more like this. And I just think that creates a lot of roadblocks and confusion for staff.
Yeah. I mean, it is a common problem and I understand how it happens. And it's the sort of thing that every once in a while, you just have to step back from your zoning bylaw or ordinance and just do a cleanup. These things happen.
Mhm.
You just fix them when you find them.
Yeah, things change. So your building commission, somebody's gonna walk in and even after you get this done, somebody's gonna walk into your building commissioner's office and say, I want to do this. And he's gonna say, I never heard of that before. There's nothing in the bylaw about that because, new uses come down the pipe and
Yep,
nobody,
yeah. Battery
No
storage was the first big one for me.
marijuana,
Yeah, but battery
No.
storage, like people were using solar bylaws to regulate battery storage for the longest time, like because nobody had battery storage. Like, how do you fit that into your bylaw? Like, it happens all the time. Like, I get it.
Definition.
catch-up process, zoning bylaw is always kind of catching up with problems or new things.
It's never ending process. That's zoning for you.
Is it your thought definitions should only go in definition?
Yes,
Okay.
Yes.
So again, there were certain bylaws, solar, that had a set of definitions that were only really,
Solar related.
perfect solar related. So a lot of times we kept them in the bylaw,
Mm.
but your thought process is just put definitions under definitions and that's it.
yeah, and we've dealt with this before, solar signs is another one that's like a god awful long list of, definitions associated with. And there are ways in the definition section that you can like color code or put a border around to kind of make it clear that,
Oh.
these are definitions that relate to solar, or these are definitions that relate to signs. We've just been able to do it just by the design of the page. So it is just much better to have definitions go with definitions. People are going to look at the table of contents and say, oh, there's a definition section.
Yeah.
I guess all the definitions are there, but they're not. Holy moly. No.
I think I'm guilty of doing that for at least one of the bylaw revisions we've had recently. Solar.
Yeah, that's so.
All right, you're forgiven.
Any further questions for them?
How many do you want?
I thought of two more when folks were just talking. You also had mentioned like the purpose statements for the zones themselves, but are there other parts of the zoning bylaw, even if it's not related specifically to the zones themselves, that you were unclear what the objective of that regulation was for, and we should therefore think about what the purpose of that might be? Kind of to go hand in hand with the policy consideration.
Well, that's a good question. And I'm going to give you a very generic answer because I don't have the bylaw open in front of me. But sometimes I find that particular provisions have a clear purpose statement. And some of it is just because there was a model bylaw out there for solar, for telecommunications or whatever, that there were purpose statements laid for, and communities simply grab them. But at the district level, it's remarkable to find an absence of a sense of what is this district supposed to be. And I think it would be helpful to your boards and commissions and applicants, but certainly to the boards and commissions to know this is kind of what we're trying to do in this residential district versus this one.
Yeah, to answer your question, from my perspective, and we noted there's some subsections that are incredibly vague. And we're saying, well, what was the intent here? What was the town trying to accomplish when this language is so very vague?
Yeah.
So there are sections like that. So I think Judy had one bullet point on vagueness, maybe more than one on vagueness. And so we will have specific examples to ask you, what was the town thinking? And often we get an answer is nobody knows.
That's for us.
That often happens. But if you've got some people that have been around for a while, hopefully they remember when it was adopted and you can get some history. And sometimes that history is pretty funny.
Oh, yeah.
The reason why it was adopted hasn't been a reason to keep it in the bylaw for 25 years, but there it lies. So those kinds of things, I think, relate somewhat to your question.
All right. Any additional questions?
Thought you had two.
Oh yeah, the second one.
You're welcome.
I don't think we touched on it tonight, but I think it was at least somewhat part of the report, but like the districts themselves and, like commercial versus business. And
Yeah.
are there other things we should be thinking about, just even in terms of like the naming of those kinds of districts? Like, is that similar or very dissimilar to like how other people are doing it?
Well, I don't think I've ever seen industrial garden district anywhere in my 36 years in this business. That was an interesting name. It left us scratching our heads. You might want to think about what do you
Industrial Garden Park.
with the name of this district?
Yeah, there's no gardens.
So it really kind of made me wonder, like,
Actually, there was.
It was.
Yeah, when
what is the purpose
when
of
it was
this?
created, it was all
Sorry.
farm field.
Farm field.
Lawn gardens.
I mean, that's just like, what do you want this district to be? You could probably name it something that's a little more like what you think of it as.
Warehouse space. Sorry.
An industrial district. I mean,
Yeah,
And
well, the industrial was a lot more lenient than what we wanted the industrial garden park. The industrial garden park, we wanted more manufacturing facilities.
Yeah.
Industrial opened it up to a lot more. And
So-
industrial was along the
Yeah.
railroad. This
Yep.
was separate on the south end of town.
we've seen that before. It's just that that's not typically the name you would
The
find,
name?
So it's just the name.
you know. I mean, not to be cute, but sometimes you just find it as industrial A, industrial B, and industrial A is where you want the higher end uses, and industrial B is where the, you know, the landscaping contractors' yards can go. I mean,
Yeah, that makes
just-
sense.
that's all.
So what about like commercial and business? I've seen other cities, business 1, business 2, and it's divided by what's allowed within those zones. Does that
Yeah.
make sense
Yeah.
or?
There's a lot of
No, it-
communities that have multiple commercial districts or business districts, and so
Yeah.
you have a central business district that might be your town center area or a town center district, whatever you're gonna call it. You might have a highway business or a general business that might be the outlying areas where the business districts are. You could have a neighborhood business district. Depending upon the form of development in your town, you might have, you know, sort of crossroad areas where you might have an opportunity for a small neighborhood zone, and then people aren't having to drive multiple miles to get a gallon of milk. So, those are the types of business districts you typically find.
Yeah.
And they might allow office or retail or whatever, but the sort of division of commercial and business is a little bit weird.
I know other communities. So I used to work for Amherst a couple years ago, and they did it like on a numbering scale. So like residence 1, 2, 3, and then it did the same thing for business and industrial. But the numbers represented like a certain density. So if it was like 1, that'd be like your lower density. I also could have that flip flop. 1 was like lower, and then 4 was like your high density. So like your downtown versus like what you see in the outskirts. And if you looked at their zoning map, everything on the outskirts of downtown is like that lower number for low density, and then you get closer to the center, and then UMass and other places, it gets more intense. Yeah, so I think it's just, I don't know, it kind of, it's like a metric when you think about it, if it's applied that way. But yeah, I mean, that's a lot of stuff to consider too, and a lot of work that would be involved in something like that. And I don't know.
There's a lot of ways to name districts, as you all have seen, and we've seen 1,000 different ways. But the ones that do it best, however they name it, are districts that actually reflect what the town wants in certain locations,
Yeah.
or what is already in those locations. Where your town center is, where, you know, do you have any village centers? Do you have a strip commercial? Do you have, do you already have heavy industrial, or do you have just light industrial uses? So, you know, looking at what you already have and what you want to have, then that can help shape the names of the districts and the locations of the district.
That was the last thing I thought of. I'm sure there's,
But notes everywhere,
What I
but
was gonna say.
oh, I'm sure we'll have more once we digest it all and. Just at the
Well,
first.
if you come up with more questions,
Mhm.
you know, like on your drive home tonight or over the next month or so, feed them to Rob, feed things to Rob so he can get them to
Thanks,
us,
mate.
and that would be very helpful. Or thoughts, or ideas, not just
Yeah.
questions.
There you go.
Thank you.
Yeah, those guys know who I am already.
Sure.
Appreciate it. I'll give you a parting link, Joe. Here you
All
go.
right, well, we appreciate your time and joining us.
Thank
And
you.
for this report.
Yes, thank you. It was definitely very helpful to think about all of that and have it presented.
Yeah.
And Judy, we can talk about this further when we have our next meeting too, and just kind of start talking about next steps and stuff.
That's fine, no problem.
Cool.
Right.
Well, thank you.
Yeah,
Thank
thanks.
you
Very,
very
very
much.
helpful.
Take care.
Very interesting.
Bye, folks.
Yeah.
Bye.
Thank you. Any new business for the bylaw review committee? I will entertain a motion to adjourn.
So moved.
Do I have a second?
Second.
Any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? We are adjourned at 7:20.